Continuing with the crying parade by the anti-gunners this week, Merrick Garland, the Attorney General of the United States, and the Department of Justice have appealed to the Supreme Court, asking for them to please side with us on gun control. And this particular subject has the liberals' heads exploding. Before I tell you what it is, I want to thank the sponsor of the video, and that's CMMG. CMMG makes a lot of items that are long or short. They have surface area suitable for shouldering. They have some without that as well. And because they are awesome friends of the channel, they are offering you a code to use to save 10% on your entire order of things. It's GNG10. Thanks to everybody at CMMG. I love those folks, seriously. Not only do they make great products that run phenomenally, but all the way down to the ownership, they are solid 2A people, and that means a lot to me. Thanks to CMMG, I appreciate it. Guys and gals, let's talk about Merrick Garland and what he has done this week. I'm going to give you a little bit of a refresher because I already covered this in a video, so I'm not going to get too deep. But the Fifth Circuit U.S. Court of Appeals 3-judge panel ruled in the U.S. v. Rahimi case that the federal law that prohibited people from owning firearms while they're under a domestic violence restraining order was unconstitutional under Bruin. Now, the Rahimi case, he is not a fantastic candidate for this perceived court of opinion around this ruling, but that's what makes it phenomenal, because the Second Amendment is for everybody. If courts did what they were supposed to, if liberal cities did what they were supposed to do, this guy wouldn't have even been in this scenario, because he was probably a bad cat. I mean, not a upstanding citizen. However, our country of laws treats everybody the same, and innocent until proven guilty is a thing. So this court sided with Rahimi, saying that, look, you can't take his guns away because he's under a civil restraining order, which he was not convicted for. He hasn't even been to court for it yet. You can't take away his rights. That's not innocent until proven guilty. So they overturned that rule, that law, actually, and said it was unconstitutional. I'll pin my video. It'll float above if you're on YouTube. If you're not on YouTube or on the actual desktop, I'll put it in the description and then pin comment. That's the U.S. v. Rahimi case. Immediately, Attorney General Garland came out in opposition, immediately, the same day. He said that, among things, that the evidence was overlooked, the strong evidence overlooked, in which there's a strong history in this country of government disarming dangerous people. And just like the laws that they looked at or they submitted for the historical context in this 3-judge panel ruling, he's talking about the surety laws back in early Massachusetts, back in the colonial days and just after the Revolution. There were things called surety laws. If you had threatened somebody or they were in fear that you were going to do them harm, you had to post surety money saying, you know what, I'm not going to hurt them, and here's proof, and then after a certain period of time, you got your money back if you didn't do anything. But those laws were very, very rarely enforced, which is one of the things that the 3-judge panel looked at. Well, Merrick Garland and all of the anti-gun boobs out there couldn't stand it when that law was ruled unconstitutional, and heads exploded. There were things that were done behind the scenes by the DOJ saying, we're going to fight this, we're going to continue to fight this, and now they've gone to the Supreme Court asking for help, the same way that GOA went to the Supreme Court asking to stop the Second Circuit U.S. Court of Appeals from putting a stay on all of the decisions by Judge Sotheby that said that the CCIA was unconstitutional. Very similar, except this one is trying to go against us instead of supporting us. Now we'll wait and see what happens with what the Supreme Court says related to this case. I'm gonna go out and say, my prediction is that they're going to deny this attempt by AG Garland and let it play out in court, just like they did with the Second Amendment issues in New York. And why? Because if you follow Bruin, the text, history, and tradition of this country, nothing says disarm people because they have either done something that puts people in fear or have been alleged to, because I can tell you that there are a lot of instances with restraining orders where they're used as a tool by attorneys Bicker all you want in the comments, bicker all you want, but that's a fact. And throughout a long career, I saw it more often than not. Yes, there are domestic violence issues where a restraining order is issued for what the intent was, but there are also issues where it's issued because of a tool or a way to attack people, and it happens on both sides of the coin. And because of that, that should bring the court into play more to make sure that people who are wrongly accused aren't disarmed. And that's what the court kind of did in the Fifth Circuit Court of Appeals. So that is going to be a big issue right now. The Senate Judiciary Committee, they already had a hearing about going around Bruen for the domestic violence issues, which is in direct relation to what Merrick Garland just did after the hearing. And that's to say, Supreme Court, we hate you when you're saying things that we don't like, but we love you right now because we want you to take our side. We'll see what happens, guys and gals. I'll keep you all in the loop. Check out CMMG. 10% is a huge discount when you go there and you buy tools for your everyday usage. GNG10 is the code, guys and gals. Thank you for all of your support. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see you all on the next one. Take care.